We're live.
Right, we are back in the Senate Judiciary. It's January 29th. We are now going to have the discussions and votes of both Christina Nolan and Michael Dresser for appointments to the Vermont Supreme Court. I feel that we can start with Ms. Nolan. We can have the discussion, Ms. Nolan, and then you can presumably entertain a motion one way or the other. So is there anybody who wishes to start this conversation? I'll start it at second place.
I think listening to Ms. Nolan throughout a couple of weeks now, along with her resume and so on and so forth, I don't see anything that is an exemplary resume, and I like her responses to the questions that were asked of her. I know it's been a lot of. We've all received a lot of texts and emails and so on and so forth in reference to which way we should go on both candidates, but we're talking about so presently. And I'm comfortable with it. I realize there was an incident that she had explained herself to us in the courthouse and so on and so forth. But I feel comfortable pushing her to.
So, just to pick up on the courthouse incident, I was initially concerned about that. That is the firearm in her bag. I thought she answered it very well. She acknowledged that she had made a mistake. She took action to educate herself about the issue and went through a pre-charge program. And all of that suggested to me that she was giving it the appropriate weight and was not above saying that she had made a mistake and was willing to fix it. So I was satisfied on that count.
Yeah, I think one of the things that really caught my interest going through this whole process was the fact that, yes, she was a federal prosecutor, but in her previous professional career and also now being a defense attorney, so having both sides of the table, if you will, it really struck me that she can understand from the victim's point of view what both sides are going through. So I'm happy to learn that and happy to support her going forward.
They had really significant concerns coming into this hearing, and I came into it, like I said, with pretty significant concerns based on some things that the nominee had said publicly during campaigns and publicly while she was the U.S. attorney. Throughout the course of the hearings, I felt the nominee answered those concerns in a way that was deeply committed to the Constitution, deeply committed to upholding the rights of Vermonters, and deeply committed to, and I will use her word, being a bulwark against the threats to civil rights and due process and just our rights generally that are coming from the federal government. I believe very strongly that people grow, people change, people develop, and the nominee's willingness to admit to that growth, that change, in spaces where she viewed she had made the wrong decision, has left me in a place where I feel confident that she is committed to upholding the rights of Vermonters, regardless of what her personal views may be. And that she's committed to continuing to keep an open mind, to grow, change, and to really learn from the people of Vermont. And so with that, I do feel that I can vote to support this nominee, and that her testimony and frankly some of the things we got from people she had been a prosecutor against, I don't really know what the right word is there, in support of her, really shine a light on her openness and willingness to really look at things and examine her own bias and where her views came from. And so with that, I will be supporting this nominee, and I really want to thank her for coming in and changing my mind.
Yeah, well, I don't want to belabor the points that have already been raised. I agree with everything that's been discussed. I do find her to be a well-qualified candidate with a breadth of experience. I know there is concern about the fact that she was a prosecutor, and sure, in more casual settings, I love giving prosecutors a hard time, but uh, on a more serious note, prosecutors do make great attorneys. They're regularly in the courts and they're regularly dealing with uh, fundamental rights related to liberty. And as Senator Maddox mentioned, she was a defender prior and she's now a defender as well. So that's good breadth of experience. Regarding the gun issue, that was initially a red flag for me in terms of judgment, really. It was a mistake, and it was worrisome. I think, though, that her testimony and the voluntary actions that she took afterward, like going to the firearm safety class, I think that speaks to her integrity to be accountable for a mistake and not make that mistake in the future. So I'll be voting yes. And I'll leave it at that. So I would entertain a motion to vote her out.
I'll recommend to vote, out favor of the position of Supreme Court Justice.
There's a second.
I'm a second.
Senator Wilson. And Senator Maddox, whenever you're ready.
Senator Norris,
Yes.
Senator Baru,
Yes.
Senator Maddox, yes. Senator Bichowski,
Yes.
Senator Rasheen,
Yes.
5-0-0.
So some additional steps we have to take after that is just we have to bring that up to the clerk's office. So that brings us to the confirmation of Michael Dresser. Is there anybody would like to start this discussion?
I'll start the discussion again, as I was. This one is not quite easy for me. I've been running around it for a while, but I guess, from the numerous or hundreds of emails we've all received in reference to the nominee. I guess I would ask, as we've been in training, to explain that process of which Mr. Drescher wasn't prosecuting individuals that have come to our attention. So several, explain that to the viewing audience, that what the process actually was at some place.
Yes, I'll do my best, keeping in mind for the audience that I don't practice in federal court, and regarding this process, this was something that I had to learn a lot about as well. I had some misunderstandings several weeks ago when I first approached this issue. Since then, I've read the federal pleadings, spoken with other attorneys to try to get a better understanding as we approach this decision point. But to your question, yes, there is what I think a misunderstanding that Mr. Drescher was, quote, prosecuting Mesa Oster and Los Madawi. I think that the easiest way to look at it is that anything involving the commencement of the immigration proceedings, put that over here under the umbrella of Marco Rubio, let's say. And so that's the immigration proceedings. However, whenever anybody is detained, they have a right to make a petition for a writ of habeas corpus. And that is what that means, is essentially challenging why you're being detained. And there is the petitioner and then the respondent. Mr. Drescher's role was a defensive one because the petitioners, Wilson and Mesa, they filed their motion, their writs of habeas corpus, and it was Mr. Director's responsibility to respond to those writs. And so that was his role in this, to the best of my understanding.
And hopefully that explanation helps, several people watching. And because of that, I feel, in my mind, if we just took those two individuals out of the picture and looked at Mr. Drescher and his, resume, his experience, dedication, and keeping in mind that he was not a political appointee from the current administration. He slid into the position because of where he was within the office. He was second in charge. He slid into that position. He had several options that were available to him. He explained those options to us. But he felt when it came down to it that if he simply resigned and walked away, that the current administration would put one of their appointees in there and just go the direction he didn't necessarily want these cases to go. And also take a testimony from, ironically, one of the attorneys who was the partner of the individual who actually was defending Mr.
Who was
most of, when asked if he was afforded due process after, he said yes, he was. When asked if he did anything that was unacceptable, he said no, he did not. And he says basically what he said was it took courage for what he had to do. So because of that, I've been wrestling back and forth with it, but I feel comfortable with this where he was the direction of the pretty good man.
If I can briefly interject, just to clarify, I believe what Mr. Martin, you're referring to Mr. Martin, I believe it wasn't unacceptable, it was unethical. He said that Mr. Director did not do anything. That's what I remember.
Yes.
And again, this is from the best of my memory, I believe Martin's primary concern was the courage to do something different. And I believe the position was that Mr. Drescher should have had the courage. That is to the best of my memory. If anybody remembers it differently, please correct the record, but that was what I recall from.
Just on that, Charles Martin did follow up with an email to clarify some of his points around whether or not Mosek was offered due process. I believe what he testified in committee alluded to the fact that he felt Mr. Trucker brought due process, and his follow-up email clarified that he meant that he did eventually get due process, but that it was not at Mr. Trucker's situation.
Further discussion, anybody else?
So it's a little bit different for me. I don't come from a judicial background. So the process has been pretty eye-opening because a lot of the responses that I've been getting in emails and whatnot, I had the same thoughts at the beginning of this whole process about the cases that Mr. Drescher was involved in, and learning more about the process, about how applicants go forth to the judicial nominating board. The nominating board will interview all the applicants, and then after that, take a vote and send those to the governor, for the governor to choose his appointees in this case. So it's been going through a process, and now it ends up in our committee here in Judiciary. And we get to hear personally from the nominees, in this case, Mr. Drescher. So it's been eye-opening for me to actually learn about, the immigration law and how that works, and what Mr. Chair spoke about before about the process and the habeas corpus, how that works, and what Mr. Drescher's role was in those cases. It's been very enlightening and made me feel comfortable being able to support Mr. Drescher in his appointment, because I think the body of work that he's done being in the U.S. Attorney's Office for the past 20 years, working through many different administrations, never being politically appointed. Like Senator Norris said, it's by statute that he went from number 2 to number 1. I feel confident in the work that he's done in his current position, in his previous professional life, that he'll be able to be an excellent Supreme Court justice. And the concerns that I hear about the two cases, mostly, learning the intricacies of those cases and what his role was, makes me feel even better about what his positions were. And I know Mr. Martin clarified his comments afterwards. But it sounds to me, based on what Mr. Martin said and what Mr. Drescher said, is that when he got involved, that there was the due process afforded, whether it was with the courts and what Mr. Drescher did. I feel confident that he can be in this role and provide an admirable service to save the money. Anybody else?
Yeah, absolutely. So I also learned a lot about what the role is of the U.S. attorney in this position. And to the chair's point, one of my concerns is the limited state court experience. To your point, they're quite different. What happens in federal court and what happens in state court, to the extent that our attorney chair didn't really understand that process. And so that is one of my points of concern. I also am deeply concerned with these two cases, notwithstanding, with the lack of insight in attending a press conference and praising this administration. And while I recognize the case that was being highlighted was an incredibly important case to prosecute, the fact that the nominee had no insight into how this administration is using cases like that to broad brush paint all immigrants as human traffickers and criminals and to justify their actions is deeply concerning to me. And there is no ethical or legal requirement for a U.S. attorney to attend press conferences. I also am concerned with the manner in which the incredible amount of public concern was dismissed as simply not knowing the process and not really understanding. And while I understand that's true, I think that public opinion and the public view of trust in our courts is at this point in time more important than ever. And whether they understand the process or not, they are the people that have to trust our courts will stand up for their rights. And what I've heard loud and clear is they do not. And I am deeply, at this point, I think Supreme Court justices should always be taken very seriously. But at this point in time, with assaults on our rights across the board, I think it's even more important than ever that we have someone who is courageous and has the insight to understand the impact of their actions broadly. And, you know, this decision will impact jurisprudence in Vermont and in many instances nationally for generations to come. Vermont has a long history, as has been pointed out, of setting precedent, whether it be with the partial abolition of slavery or whether it be the rights of same-sex couples. We have a pretty long history of really setting forward what happens nationally. And I'm not convinced that this nominee is the right person at this time to gain public trust, to have the insight to truly stand up in opposition to what we're facing. And for those reasons, I cannot support the nomination.
Thank you. The quick response to the state court experience piece, I did raise that as a concern. And again, I don't practice in federal court, so it's this is an area I had to revisit and relearn. But Mr. Director did provide a letter dated January 27th, and does go into more detail about his state court experience and how how state law can be litigated in federal court, though it uses federal procedure, rules of civil procedure, rules, federal rules of evidence. And so it's just some information I wanted to put out there regarding that.
Well, that makes sense, because I don't know that I've seen that.
This one? Yeah, I got it. This one.
Posted. It should be
On the third page.
Yeah.
Got that. see that, I'll take a look. I just, when, you know, I think that, you know, jotting down the 3 trials that they gave it just doesn't seem good enough for me, but I will also do this.
And if I may, I would also say, you know, through this whole process of learning, the Supreme Court is also very different than the state court. Vermont Supreme Court is very different than the state court. So, having been in federal courts and some state experience, all leading to being in the Supreme Court, and you should acknowledge that the Supreme Court is also different than the state court.
Yes, and what I would add to that is, you know, in state court, you're dealing with state law and state constitution and questions or conflicts of state law and the state constitution would go to the Vermont Supreme Court. There are circumstances where a state Supreme Court decision can be appealed to the U.S. Supreme Court if there is also an involvement of federal statute or the U.S. Constitution. But I'll just leave that. And Bruce? Your thoughts?
Well, like Senator Norris, I have wrestled a lot with this and lost a lot of sleep over it. I think both nominees are good people. They came in and they were intelligent and personable. And I hope nothing that I say will be taken as disparagement of Mr. Drescher, because I thought he gave very credible testimony. It was not ultimately enough for me. And for me, it comes down to the Moser Medallion case, which had a particular, perhaps personal impact on me. And what I come back to again and again is what Mr. Drescher said was that it was very rare, I think he said extremely rare, he was acting U.S. attorney, but for the head of that office to take on the Medallion case was extremely rare. And his rationale was that he was protecting his subordinates in so doing. And in the Senate, we don't get into intentions, and so I don't dispute what he says about some intention. But what I would say is that what bothered me more than anything in this moment in time is that I feel that we have a regime in Washington that is openly corrupt and dangerous. And it's a difference in magnitude from the first Trump administration. And there is a logic that says better that I should be in this job than that I leave and then someone worse come in. And I feel like during the first Trump administration, many people maintained that and they stayed in their positions and they contributed to actions that I wouldn't agree with. Again, I think this is a quantum leap forward that we're seeing now in terms of danger to the republic itself. And so I feel like people who supported Mr. Drescher were in essence saying, we understand that you feel you need to draw the line, but you should draw it after Mike Drescher. And I just don't feel that I can do that. I feel that the system that arrested Mr. Medallion had been hastily put together. It was, in my mind, unconstitutional. It was directed at spearheading him out of the country to somewhere where he'd be unable to defend himself. And it was only very quick thinking that kept him here. Now, supporters of Mr. Drescher would say that he had no option in that case but to defend the government, to defend this system that was being put into place to circumvent well understood legal rights. I have tried and tried to see it that way, and ultimately I can't make my conscience go along. So I would say reluctantly, I vote no against Mr. Drescher, because the time to draw the line has come. And I can't make myself draw it after him. It has to be now if it's going to be drawn at all. Thank you.
Yeah, like everybody, this has been one that has been. Well, I'm not exaggerating when I say it. I think this has been the hardest decision I've had to make since being here. It's been essentially two different schools of thought butting up against each other since this confirmation process started. And after learning a lot more, well, I'll say this, at the very beginning, when actually both of these nominees were coming to this committee, I could essentially see a freight train on its way to the committee. And we all jumped on that train and stated this process patiently and with due diligence. But since we've started the process, I've learned a lot more. I was initially far more concerned than I am now, though I do still hold substantial hesitations. And that's why we have these hearings. That's why we get testimony, written and live testimony, and that's why we do our research to learn more about this and make informed decisions. And where the conflict for me arises is now, as I understand what Mr. Drescher's positions were, wearing my attorney hat, I can understand why he was making those arguments and what those arguments meant in the context of that process as best as I can. And where that butts up, though, is with my role as a senator and hearing from not just hundreds of Vermonters across the state about their fear and anger towards the issues that we're seeing today, but specifically for my district, dozens upon dozens of Lincoln County voters and residents and attorneys I've worked with and have known for 15 years, people who have really shaped the way people who have shaped my current perspective and respect for the judiciary, and also including two retired judges from the district. And I know that Mr. Drescher and folks who supporting Mr. Drescher obviously disagree with those perspectives, and I appreciate their concerns. But I guess the question becomes, at what point are my constituents right, regardless of what I have learned or how I feel regarding specific procedural issues and questions of law that arose recent incidents. And in this moment, I'm wearing my Senate hat, and I have to vote in such a way that I think my constituents expect of them. And so that is to say that I will be voting no. It's been very difficult to get here, and I have no doubts that Mr. Drescher has integrity. He's very intelligent, and we did hear from a lot of his coworkers, former coworkers, about how great a colleague it is. But I still have to look at, actually, Senator Bruce, you mentioned that this moment in history, and what constituents, Vermonters are expecting from their elected officials. And I think that trust is, well, I want people to be able to trust government And I want them to be able to trust, whether it's the judiciary, executive, or legislative branch, I want them to be able to trust that their elected officials will make the decisions that they expect them to make. Especially when there is a chorus expecting them or demanding that they vote a certain way. And especially given the context and the circumstances that we find ourselves in this country. So I'll spare you any further philosophizing. I'll save it for, but that's all to say that I'll be voting now. So I would entertain a motion, though I'm not quite sure at this moment what motion we opted to.
I'll offer, a look at what might happen. So I am, first of all, I commend you, the chair, for the way you've run these hearings. I think it's been fair, careful, judicious. You have taken in all of the testimony, and I would extend that to my colleagues. I think everybody has done a lot of work, but also done that work in the proper way. So if we vote, and it seems now that the vote would fail to move Mr. Drescher forward with a positive recommendation, I believe that we should start with a motion to move the nomination favorably. So someone who is going to vote that way, I would hope make that motion. If that fails and the vote is against the nominee, I would then move that we send the nomination to the floor, because I think this is far too important to have one committee have the final word. So I think it needs to go to the full Senate. I would make that motion in a particular way. I would not ask that it leave here with a negative recommendation, because as pro tem, I've worked with the chairs to try to make them understand that bringing things out with a negative recommendation is sometimes a subversion of the committee system. So I would ask that they come out with no recommendation. If that motion fails, someone could then move to bring it out with a negative recommendation. So I don't want to make the positive nomination, but I believe that's where we should start. Sarah, those.
I'm so sorry. The options, the sort of three options are favorable, not favorable, and then no recommendation.
Right.
And I guess given the vote, I'm just a little confused why we would not represent that vote accurately on the floor.
The vote will be represented accurately, so the chair will explain the vote and make it clear that the nominee failed to get a majority. But without going into it too much, we've had a few instances where committees have voted bills out with negative recommendations, with the idea that once they get to the floor, there are enough votes to pass it. I think that weakens the committees in their work. So in part to not contribute to that, I would be moving that this come out with no recommendation. But it would be clear that the committee is not recommending this nominee and the vote was against it.
Okay, so that's helpful, because the way I was sort of viewing the three buckets was as positive, neutral, and negative.
No.
And I don't believe.
No, I view it as no recommendation. So in other words, the vote is speaking for itself.
Okay, I recognize this is not a common occurrence, so I was kind of processing it through my brain to sort of challenge myself out of the positive, neutral, or negative space.
So again, I think it's standard practice to begin with. Does somebody want to move the nomination favorable?
I'll make that motion.
I'll move it favorably.
Any further discussion? So we can call the roll on that one.
And I do think we should call the roll on all of these motions. Some separate piece and then.
Yeah, maybe while that's printing, if you wanna.
Yeah, I'll do that. I'll do that. Well, thank you, John.
Yeah.
Okay. Thank you. All right, so where we're at, voting to confirm favorably Supreme Court Justice nominee, Mr. Judges. Senator Norris.
Yes.
Senator Baru.
No.
Senator Meadows, yes. Senator Bihowski.
No.
Senator Hashim.
No,
That is a 2-3-0 favorable vote.
so
Unfavorable. I'm so confused. I'm sorry.
well, so my understanding is when we just had a motion for a positive recommendation. Took the vote on that, the majority was that we do not move forward with a positive recommendation. And that keeps it in limbo essentially for that motion.
Okay.
And so it can't go, my understanding is it can't go to the floor with a 2-3 vote of a positive recommendation.
I think if we were to do nothing now, it would, die in the. Right.
So, yeah. Senator,
So as I described a minute ago, my motion is that understanding that there was a failed vote to move the nomination favorably, I do think it should go to full Senate. So I would agree that the nomination goes forward with no recommendation.
so my initial response and hesitation, sending something out with no recommendation. I understand your position. I respect your position as pro tem and the precedent that you're trying to establish or that you're trying to avoid changing. As the chair, I hold a concern mainly because I feel that the Senate as a body expects us to come out with a suggestion one way or the other. And considering the amount of time, testimony, and work that we've done on this, it would feel strange to me that at this point we can't represent to the Senate yes or no as a committee. That's a challenge to me at the moment, so I'm not quite sure.
If I might, I think as chair, you will summarize the committee's discussion and the vote. And so it will be clear that the majority of the committee voted against Mr. Drescher. So it's a procedural nuance, whether it comes out with a negative rejection or a negative recommendation or no recommendation. I think it's, from my point of view, it's a distinction worth making in this case. So I will just say I've made that motion. Should it fail, someone is free to make another motion for whatever reason they like. So
You mentioned a distinction in this case. What do you mean?
well, in other words, I think, as you said, it seems important to the committee not only have a negative vote, but send a negative recommendation. And I think that the Senate will take direction from us to a certain extent with our negative vote. And people will make up their own minds about the issue. So I don't think it'd be a material difference whether it's no recommendation or not. I don't know.
So I think the chair did a better job sort of expressing my concern, and I wonder if I might ask for maybe a 7-minute break so that I might have a brief conversation with our parliamentarian to understand the procedural nuance.
I think we should continue with the vote. I don't like stopping in the middle of the action. Yeah, so I think
What? Can you
I just,
share what your questions are so can be perhaps,
I don't know that I don't know that, I'm trying to understand the procedural nuance and I don't feel comfortable taking a vote that I don't fully understand. That does not make me comfortable. Because I share your concern that issuing no recommendation is neutrality, and neutrality is never what we do when we're faced with hard stuff. But I hear you saying that it's a procedural nuance that I imagine our parliamentarian might be able to help me understand. But if I am forced to take a vote that I don't understand, I will vote no.
and
going to ask, want to make sure that all the committee has an opportunity to chime in on how they feel about this. And I think there's merit to both sides of the
I
argument.
just feel if there's a motion on the table, it's not regular order to then
Take a break.
take a break.
Maybe
Have the motion be withdrawn.
I would prefer not to withdraw it.
let's,
And if someone feels they need to vote no, then that is certainly an option.
Senator Norris or Senator Reynolds, what are your thoughts?
I understand where Senator Foote is coming from, and I will second his motion.
Yeah, I understand what Senator Baruch has put forward for a motion here, and not setting the precedent to continually bring out negative votes and things like that. And like the chair will do on the floor, I'd imagine, is make that be known and it's public knowledge for what the vote is. Right? So giving the opportunity to the full Senate for the confirmation.
And I would say there will be no misunderstanding after this hearing that we have voted Mr. Drescher down.
Well, it sounds as if there are at least 3 yes votes, regardless, for sending the pressure out with no recommendation. That's the motion that we have on the table. Contemplating it, but we have this brief pause. So all right, well, that's the motion that we have. It will remain my opinion that generally a committee should provide a yes or no vote or a yes or no recommendation to the Senate. But I understand the situation that we're in, and this is a unique one. So yeah, that's my position. I'll be voting no on the recommendation, but I understand we have 3 yes votes in support. So unless is there further discussion? Okay.
Senator Norris,
Yes.
Senator Baruch,
Yes.
Senator Meadows, yes. Senator Mihoski,
No.
Senator Basheen.
No.
3-2-0.
So, both nominations would go to the floor. There's no one's with positive recommendation and the report of our votes. And in this case, the report of our votes and no recommendation.
So I guess then the next question becomes, I mean, I had anticipated reporting out both of these nominees. I will report out Ms. Nolan. So that kind of, but so I guess that raises the question then of who wants to report out the director. My understanding is, and correct me if I'm wrong, have this realization
voting no. We vote no on the recommendation. The person voting no isn't able to report. Is that correct?
I think the chair can always, because you're being asked in this situation to summarize the work. But if you choose not to and you want to delegate that to somebody else, then there were two people who voted favorably for Mr. Gotcha.
I would prefer reporting. Yeah, it would be my preference to report Mr. Grusher. My intention for both of these folks was to provide an unbiased and objective summary of their resumes and the answers provided in testimony to supplement their experiences. And then following that presentation, send whatever the committee's decision was. So we are providing no recommendations. So well, let me ask this. Is there anybody with a burning desire to report out Mr. Greshner? And then I'll get your questions. I'm happy to do it, and I'll provide, like I mentioned, an objective report of his resume and experiences, followed by a persuasive argument that we don't have a recommendation, but in trying to explain why there's no recommendation. That's what I can. If I did not anticipate, that's what I would be presenting.
I think you can confine yourselves in vote if that's the important thing. So now that was the first order of business, was the vote to confirm and fail to.
So I'll report it out and just I'll figure it out. Consider the host.
Kind of a question, kind of a statement. I think generally speaking, and I mean, this is a weird situation because we're not having a recommendation, but generally speaking, chairs usually report out and secretaries in those high level positions. So it makes sense to me for you to do Supreme Court justices. I also would imagine that in any given report, again, this is a strange space to be in, what the reporter is doing is representing the position of the committee. And while you did vote no, that was the position of the committee.
Yeah. That makes sense. Thank you.
Of course.
All right. So any further discussion or questions that we have?
I'll just repeat, and I will say this on the floor. I think the committee did amazing work, and you were directing that work. You will remember from Zoe Saunders confirmation. Very easy for these to slip into to have an error be compounded and then have recriminations about the whole process. And I think we've avoided that. It'll go to the floor in a very smooth way. We'll have what I think will be a civil discussion on the floor, and people will vote their conscience. And that's especially important because this is 40% of the Supreme Court we're talking about. So again, I commend you for that.
Thanks, and I appreciate everybody's patience and due diligence and very good questions that everybody asked. And also a big thank you to Emery and initially Lynn, had two committee assistants do this. I'm sure been bombarded with emails for testimony to be posted, and so grateful for that. Okay, so we don't have any further business. We can adjourn. We can take those reports up to the secretary and get them on the calendar. The floor vote will be on Tuesday, I understand.